was a human rights organization based in the capital. There basically deals with the human rights of the people who are living in the Nakai River bank. And the people who are living in the Nakai River bank are suffering for the arsenic contaminated water, and according to the paragraph number 16 of the Moot Act, they are heavily reliant on the river. So they are suffering for skin irrigation and also many other diseases. And they are truly incapable to bring themselves in front of the court, and also incapable to represent themselves individually before the High Court Division. And also,
Lord Counsel, how can we draw a conclusion that this is really a public interest, not like private interest, or as is said in an Indian decision, not publicity interest or paisa income interest? Can we satisfy the court?
Much obliged, Your Lordship. Yes, of course. If we go through the latest case decision of the National Board of Revenue versus Abu Said Khan and others, which is cited in the 18 DLC 2013, it stated some criteria to determine when a petition is filed before the court. There should be some criteria by which we can understand or determine which are the public interest litigation and which are the private interest litigation. So if we saw the criteria number 1, 4, 7 and 13 of this case, then it is stated that the petitioner must show bona fide interest, and also they should have stand on behalf of the disadvantaged group, and they should have sufficient interest in the subject matter. And here LMC has no personal gain, and also they are not doing for this the limelight or famosity or any other purpose. They are only came here to support the people who are not able to go to the court. Much obliged, Your Lordship.
Land Counsel, against whom you have filed these applications, please turn to page 2 of the writ petition.
Yes, Your Lordship.
Against whom you have filed this writ petition? Is it maintainable?
I beg your pardon, can
Against whom? Who is the first respondent? Who is the respondent?
Much obliged, Your Lordship.
Seeking remedies from whom?
We
From
are
the secretary?
Much obliged, Your Lordship. We are seeking the remedy to the Bangladesh, the government, and also
What is that?
the
Is there any party?
No,
Have you
Your-
mentioned? What is the provision of the constitution? Who will be the party?
Have you made the government a party in the writ petition?
Much obliged, Your Lordship. We are filing the writ petition against all other
Please show the relevant article of the constitution. Do you have the constitution?
Yes, Your Lordship. We
Please see
are
the article 146 of the constitution. Who will be the party? Who will be the respondent? The
Much
constitution says the governments of Bangladesh may sue or be sued by the name of Bangladesh. But in the petition you have stated, you have made the secretary in the personal capacity. In
much
that case, whether the writ petition is maintainable or not.
Much obliged, Your Lordship. There was the parties who are the several ministries and who are the secretaries. We are filing the PIL against them because it's their duty according to the.
It's true, but there are some procedural formalities in the writ petitions, and this is a curable defect, right? You should have made the first respondent should have been the government, represented by so and so. This is a curable defect, and we would, if you make prayer, we would allow you to make necessary amendment in the writ petition. Is that okay with you? Yes, you may proceed now. Thank you.
Much obliged. May I proceed with my arguments?
Do you understand what my brother said?
Yes, Your
You
Lordship.
have a provision to make correction, so if you don't make the prayer, it won't allow. So you have to make a prayer first.
Much obliged, Your Lordship. Actually,
You can make a verbal prayer right now for amendment of your writ petition, and you can do it after making your submission.
much obliged to your lordship, but we are not want to amending our PIL because as per the section 4 of the Bangladesh Environmental Conservation Act 1995, it's the duty of the Department of Environment to they have the power and functions of the Director General, and according to the moot fact paragraph no 21, they have the exercise full oversight over contractors, and many of them who are politically affiliated, and also the government have severally failed to justify the project. So,
Council, you are seeking remedy under Article 102 of the Constitution.
yes, Your Lordship.
Okay, proceed.
Much obliged, Your Lordship. My second issue is that the denial of treatment by public hospitals is a violation of fundamental rights under Article 32 of the Constitution, and I will give 3 arguments to prove this issue. Firstly, right to life encompasses right to health and dignity. The state's duty to provide medical treatment cannot be excused by the resource shortage. And finally, the violation of constitutional and international obligations. Regarding my first point, Your Lordship, according to the Article 32, which guarantees that no person shall be deprived of life or personal liberty except accordance with law, which is mentioned and interpreted in the paragraph number 6 of the Moot Fact. Your Lordship, according to the 𝑏𝒂𝒕𝒊𝒂𝒕𝒊𝒐𝒏 versus Bangladesh and also Aino Shalish Kendra versus Bangladesh, the court affirmed that the state's obligation to protect life includes the duty to provide emergency medical care. Your Lordship, the victims were...
How you are aggrieved? In which paragraph you have stated that you are aggrieved? By which act or action or inaction of the government or the authorities? What is your grievances? Have you stated in this application?
Much obliged.
In which paragraph you have stated why you have filed this petition? What is the cause of action? Is there any paragraph? Please show us.
Yes, Your Lordship. We have mentioned the grounds. We have mentioned in the grounds, which is...
No grounds. Grounds you will say later, but you show us the grievances for which you have filed this petition. In which paragraph you have stated?
It is started
What
in
is the cause of
page
action?
number 3 and started from paragraph number 6, 7 and onwards. If Your Lordship has no further queries, may I proceed? Much obliged, Your Lordship. Lastly, Your Lordship, Bangladesh is also a party to the International Covenant on Civil and Political Rights (ICCPR) and the International Covenant on Economical, Social and Cultural Rights (ICESCR). And according to the Article 6, 1 and 12 of these conventions, it poses a positive obligation on states to ensure medical service in the event of sickness. By refusing treatment, the state breached its international commitments. Furthermore, Your Lordship, the right to life includes the right to health and medical assistance, which is also mentioned in the paragraph number 6. Your Lordship, may I take 1 minute to sum up my arguments? Much obliged, Your Lordship. Therefore, Your Lordship, the denial of treatment to critically ill patients amount to a gross violation of their right to life and dignity. The government's failure to ensure medical care and safe water constitutes institutional neglect that the Honourable Court must ratify. Your Lordship, to sum up my submission, the LMC has possessed the locus standi to act on behalf of the helpless citizens, and the state's denial of treatment to get the admission in the public hospitals clearly violated the fundamental rights and health under Article 32 of our Constitution. Unless there are any queries regarding Your Lordship, may the Council conclude.
Court, Your Lordship. Much obliged to Your Lordship. I'm 𝑩𝒐𝒏𝒈𝒐 the second advocate on appearing on behalf of the petitioner, Law and Mediation Center, NMC. And I'll be addressing the final two issues concerning the state's failure to ensure access to safe and pure drinking water as a violation of Article 32 of the Constitution of Bangladesh and the failure of the state to conduct environmental impact assessment, monitor water quality and prevent industrial discharge into the Natai River amounts to a breach of its statutory and constitutional obligation. Your Lordship, I would like to humbly reserve 13 minutes for my submission on these two issues. Your Lordship, may I commence with the third issue first? Yes. Much obliged, Your Lordship. My submission on third issue develops under three subjects. Your Lordship, firstly, the right to water forms an inseparable part of the right to life under Article 32 of the Constitution. Secondly, the state has failed to discharge its constitutional and statutory duties. And finally, Your Lordship, this failure constitutes a continuing violation of fundamental right. Your Lordship, I would like to start with the right to water under Article 32. Your Lordship, Article 32 guarantees that no person shall be deprived of life or personal liberty save in accordance with law. I would like to draw your kind attention to Moot paragraph 6 that says that the court with progressive interpretation, it includes the right to healthy environment as well as clean and safe drinking water, while drinking water as intrinsic right to life under Article 32 of the Constitution. And in Ain 𝒆𝒅𝒊𝒂𝒕𝒊𝒐𝒏 versus Bangladesh, 2008 BLD, this Honourable Supreme Court held that right to life doesn't mean mere survival, rather it includes the life with dignity and access to potable water. Your Lordship, I would like to draw your kind attention to paragraph 8 of the Moot Fact, Your Lordship, where it said that the state enacted Water Act 2013, which declares, section 3 of that declares that access to potable water, water for hygiene and sanitation as a fundamental and highest priority right. Your Lordship, I would also like to draw your kind attention to Moot Fact, paragraph 9 of the Moot Fact that shows that residents of rural Bangladesh are suffering from arsenic poisoning due to contaminated groundwater. Your Lordship, yet no alternative safe source was ensured, leading to widespread illness and long-term complication. Your Lordship, in an Indian case, that is 𝒆𝒅𝒊𝒂𝒕𝒊𝒐𝒏 versus state of Rajasthan, where the Indian Supreme Court held that as long as there is an existence of law and unless it is repealed, the right given under that act has to be given to all the citizens. Your Lordship, the Water Act 2013 doesn't exclude the people, those who were living around Natai River. Therefore, they deserve the protection under this act. And the
Learned Counsel. Issue number 3 is whether the failure of the state, right?
Yes, Your Lordship. Much obliged.
Basically, what you are suggesting or arguing before the court is the state has failed, right?
Yes, Your Lordship.
That is your argument.
Yes, Your Lordship.
Fair enough. Paragraph 4 of the facts that not your repetition, the facts. Bangladesh suffered prolonged economic downturn, right?
Yes, Your Lordship.
So, the economy is just stable as per agreed statement. So it will take time for the state to provide, this sort of service. So why do you call it failure of the state? Because state has very limited resource, manpower, energy. Can you elaborate on this point, please?
Much obliged, Your Lordship. Yes, Your Lordship, the people, those who were living around Natai River, they have been suffering since 2021 as per the Moot Fact, where it says that people have been suffering since 2021, but the state hadn't taken any adequate measures in this regard. And in terms of the states not having adequate time, Your Lordship, the law was enacted in 2013. The state had enough time. But yes, of course, Your Lordship, the interim government had taken over the power in 2024, but the state under this act they have the obligation, because the government has changed, state doesn't change, your lordship. Therefore, they have the obligation to ensure potable water to the people, to the residents of the Nagai River. As the Act doesn't exclude them, therefore they get the protection under the Water Act 2013, your lordship. Much obliged, your lordship.
Council, you have sought against the state, but have you filed any representation to the government for clarification of their positions? Have you filed any notice demanding justice?
Much obliged, your lordship. No notice has been filed yet, because the people, those who were living around Nagai River, they had been suffering since 2021, and it's been 2025, but no remedial steps were taken by the government, and it was a negligent act on part of the government, and it shows that the government is completely negligent to ensure potable water to the people, those who are living Nagai River. It is a clear negligence on part of the government, your lordship. May I proceed with my submission, your lordship?
Yes.
Much obliged, your lordship. To conclude with my submission on this issue, your lordship, I would like to emphasize on the point that while citizens must drink poisoned water, the right to life becomes mere hollow. The Constitution doesn't permit survival without dignity. We therefore pray that this Honourable Court to recognize safe drinking water as integral to the right to life and direct the state to act accordingly. Your lordship, if you have no further queries, may I proceed with my final submission?
Yes.
Much obliged, your lordship. Issue 4 concerns that whether the failure of the state to conduct environmental impact assessment, monitor water quality, and prevent industrial discharge into the Nagai River amounts to a breach of its statutory and constitutional obligation. Your lordship, my submission on this point also develops into three sub points. Firstly, your lordship, the state had a clear statutory duty to conduct environmental impact assessment and regulate pollution. Secondly, your lordship, its failure to discharge that duty has violated constitutional guarantees under Article 18A and 32 of the Constitution of Bangladesh. And finally, such failure constitutes a continuing breach of both domestic and international obligation. Your lordship, to start with the statutory duty to conduct environmental impact assessment, your lordship, Section 12 of the Environmental Conservation Act 1995 mandates that, in Section 12 of that, mandates that no industrial project shall commence without prior environmental clearance certificate based on proper environmental impact assessment. Your lordship, however, I would like to draw your kind attention to paragraph 20 of the Moot Fact, your lordship, where the Ministry of Industries were continuously permitting factories without consulting environmental regulators. That shows the Ministry of Industries doesn't comply with the regulation laid down in Section 12 of the Environment Conservation Act 1995, your lordship. Your lordship, I would like to also draw your kind attention to paragraph 17 of the Moot Fact, where the water resources continued to the Ministry of Water Resources continued to approve various projects without establishing proper monitoring mechanism. That shows that they were negligent about the act, or they are willingly just not doing the obligation imposed upon this act. Your
Honored
lordship,
Council, don't you think that given the fact that Bangladesh is a developing country, it needs industrialization, and it has to do some sort of compromise with the environment, water issues and development? A balance has to be struck. A bit of compromise has to be made.
much obliged to your lordship for the query. Your lordship, I would like to draw your kind attention to paragraph 20. Again, your lordship, it says that the Ministry of Industries were continuously permitting without consulting environmental regulators. Your lordship, doing it amounts to that the Ministry of Industries is not following the law, is not following the obligation imposed upon them, and it is costing the Nagai River, and it is severely affecting the environment. Therefore, there should have a balance, but they are not maintaining a balance. They are thinking that they are above the law, your lordship. They are liable for not following the obligations imposed upon them, and they should be held liable so that they can realize they are not above the law. Your Lordship, I would also like to draw your kind attention to paragraph 23 of the Moot Fact, Your Lordship, that says that eco-sentinel system malfunction, toxic effluents entered river causing large-scale contamination, and it has been happening, and it's a landmark report, Your Lordship, that says that the eco-sentinel system had been malfunctioning over 2 years, and Your Lordship, the state was not aware about this, and as a result of this, the Nata River indiscriminately get affected, and the people, those who were living around them, become the victim. Your Lordship, may I proceed to my next survey, Your Lordship, if you have no further queries? Much obliged, Your Lordship. My next point is continuing breach of domestic and international obligation, Your Lordship. Your Lordship, this violation is not historical, rather it has been continued daily since 2021 as per paragraph 23 of the Moot Fact that has been reflected in there. The Nata River, Your Lordship, as per same paragraph of the Moot Fact, remains unfit for human consumption due to persistent toxic discharge, Your Lordship. This constitutes a continuing wrong as defined in Dr. 𝑑𝒒𝒐𝒏𝒈𝒐 versus Bangladesh case, which is popularly known as Feb 20 case, where this Honourable Court, Your Lordship, said that where environmental damage was held to renew, the cause of action each date persists, Your Lordship. Furthermore, the UN Convention on Economic, Social and Cultural Rights in General Convention on 15/2002, which reiterated that the right to water and sanitation is an inseparable right to health and life. Your Lordship, in Hussain Mohammad Ershad versus Bangladesh 2000 case, this Honourable Court held that if any international convention is in compliance with the law, if there is any law in Bangladesh which is in compliance with the covenant in compliance with the existing law, then that has to be enforced. Under the Water Act 2030, this convention can also be interpreted and being violated by the state, Your Lordship. Your Lordship, the Nata River is not merely a water body as per paragraph 7 of the Moot Fact, rather it's a lifeline for millions. Therefore, the state has violated its duty to protect the people from being affected severely. Your Lordship, may I get extra 1 minute for my prayer? Much obliged, Your Lordship. Your Lordship, we pray and hope that this Honourable Court to declare that the petitioner Law and Mediation Center has locus standi, Your Lordship. Secondly, denial of treatment by the public hospitals violated the fundamental rights of the citizen of Bangladesh. Thirdly, Your Lordship, failure of the state to give access to pure and safe drinking water violates Article 32 of the Constitution. And finally, Your Lordship, failure of the state to conduct environmental impact assessment (EIA), monitor water quality and prevent waste discharge into Nata River violates statutory and constitutional obligation, Your Lordship. If you have no further queries, may the Council rest, Your Lordship.
Yeah.
Much obliged, Your Lordship.
Learned advocates for the respondents are requested to make their submissions before the Honourable Court.
Good afternoon, my lords. It's an honor to plead before this esteemed bench. I am Nadia Islam on behalf of the respondent in the case concerning the environmental justice and right to water. I will speak for 30 minutes and will address first two issues. Learned advocate from my side will address third and fourth issue. We respectfully reserve 4 minutes for our rebuttal. My lords, we have our annexures. We humbly seek permission to submit them. Much obliged, my lord. If my lords have no preliminary queries, may I proceed with the first issue? Much obliged, my lord. My lord, I shall make 3 submissions in establishing that the petitioner actually has no locus standi to stand before this court. First of all, my lord, LMC's writ petition is ultra vires as LMC is not an aggrieved person. My lord, according to Article 102 Clause 1 of the Constitution of the People's Union of Bangladesh, it is stated that the High Court Division on the application of any aggrieved person may issue appropriate directions or orders to the concerned authority. My lord, LMC based in the capital filed a writ petition. Nowhere in the moot problem it is mentioned that those families are unable to approach the court, my lord, as all of the members are not affected. Anyone from the member can, as a representative on their behalf, could have filed the writ petition, my lord. Also, my lord, none of those families have asked LMC to file writ petition, and none of the members of the LMC are affected. So, my lord, it is not LMC is not an aggrieved party as they are not affected directly or indirectly. My lord, in 𝑩𝒐𝒏𝒈𝒐 versus State of UP and others, which is a case of 2001, the Supreme Court held that a person shall have no locus standi to file a writ petition if he is not affected personally or his fundamental rights have neither been directly or substantially invaded. My lord, in Public Transport versus 𝒆𝒏𝒕𝒊𝒂𝒕𝒊𝒐𝒏 𝑫𝒆𝒅𝒊𝒂𝒕𝒊𝒐𝒏, which is a case of 1959, 11 DLR, the court held that a person seeking judicial review must show that they has a direct personal interest in the act which he challenges before his prayer.
Learned counsel, you will appreciate that nowadays in the matter of PIL, Public Interest Litigation, the concept of aggrieved person is construed very liberally. And when it comes about a group action or class action, anyone can be aggrieved. Anyone, it could be a person who is working for the marginalized or the oppressed people or a group. So the court has taken a liberal approach. So can you make your submission from that perspective, please?
Much obliged, my lord. My lord, nowhere in the moot problem it is mentioned that LMC is a registered organization like BELA or BLAST. My lord.
Have you stated this in your appeal opposition? Have you stated this?
No, my lord. Much obliged, my lord. My lord, as they are not recognized by law, they have no locus standi to stand before this court. As they are not recognized by law in jurisprudence, from the perspective of jurisprudence, we can say that they are not a legal person. My lord.
Is there any requirement that the aggrieved person has to be a legal person? It could be a natural person or some group of persons or even a non-registered body?
Much obliged, my lord. My lord, to sue or can be sued, a person must be a legal person. From that perspective, my lord, LMC is not a legal person. Also, my lord, I would like to mention Saiful Islam Dildar versus Government of Bangladesh, 50th year. In its judgment, para number 4, it is mentioned that merely because the petitioner is a Secretary General of Human Rights Organization is no sufficient ground to hold that he has a sufficient interest in the field. My lord, in moot problem, nowhere it is mentioned that LMC consistently has been endeavoring to obtain remedy for a section or group of people in the event of violation of their any legal or constitutional rights. My lord, in that similar case, it was held that a writ petitioner cannot be deemed a person aggrieved under Article 102 Clause 1 of the Constitution if they fail to demonstrate a constant record of endeavoring to secure remedies for a disadvantaged section of society, my lord. I would like to draw your kind attention. In para 28, it is mentioned that LMC just as a response filed the writ petition. Therefore, my lord, it is clear that LMC has no right to appear before this court.
counsel, you have submitted a written opposition, but have you reverted, challenged, or given answer to the paragraph of the writ petitions? As per paragraph wise, have you written this? Or you have just stated just like a statement? Have you challenged, particularly have you refuted the particular statement or paragraph of writ petition in your evident oppositions?
No, my lord. My lord, I would like to assess this court with a case which is 𝒆𝒏𝒂𝒕𝒊𝒐𝒏 versus Government of Bangladesh. In its judgment, para number 4, an interesting question was arised that can the court hold the petitioner as a person aggrieved only because his heart bleeds from reading news published in the newspaper? My lord, High Court Division refrained taking such view by stretching the meaning of person aggrieved and hold the petitioner as no locus standi to maintain the petition as he is not an aggrieved person. My lord, I would like to draw your kind attention in para 28. It is clearly mentioned that LMC just as a response filed the writ petition, and therefore, my lord, they has no right to appear before this court. My lord, may I proceed with the second submission? Much obliged, my lord. My lord, it is unreasonable for LMC to file writ petition in the High Court Division despite the existence of an efficacious remedy. According to Article 102, Clause 2 of the Constitution, it is stated that the High Court Division, if satisfied that no other equal efficacious remedy is available on or provided by other law, then the High Court Division can make an order. My lord.
What types of remedies are applicable, do you think?
Much obliged, my lord. My lord, according to the Bangladesh Environment Conservation Act 1985, in its section 8, clause number 1, it is clearly stated that any person affected or likely to be affected as a result of pollution or degradation of the environment may apply to the Director General for remedy of the damage. My lord, simultaneously, clause 2 is saying that the Director General may hold a public hearing and take other measures for disposing of an application made under this section, my lord. My lord, in Radhakrishna Industries versus State of Himachal Pradesh, which is a case of 2021, the Supreme Court held in its para 27 that high courts can turn down writ petitions, especially when an efficacious alternative remedy exists, my lord. And also, the presence of an alternative remedy does not automatically strip the High Court of its authority. Yet, my lord, writ petition should not be allowed when an efficacious alternative exists. But my lord, despite having remedies in other laws, LMC did not apply there, and LMC directly filed a writ petition. Since their
counsel, you are suggesting that the petitioner LMC has alternative remedy by way of making an application before the concerned authority under the statute. Is that right?
Yes, my lord.
Okay. Isn't it like I am complaining against you and I am making an application to you to rectify it. In service matter, it is called like Caesar to Caesar. Do you, a man of ordinary prudence, a reasonable person, can hold that such alternative measure will bring a fruitful result unless a judicial intervention is required? What is your reply to it?
Much obliged, my lord. My lord, since we are not saying that since it's an environment related dispute, the subject matter of this dispute is environment. Since they have other alternative remedies, they must have tried there first.
Are they efficacious? That is the question.
Much obliged, my lord. My lord, according to section 4, clause 1, it is stated that after receiving the application, Director General will decide or issue necessary directions in writing to any person for the discharge of these duties under this Act. My lord, Director General will provide the remedy according to the necessity and according to the situation. Much obliged, my lord. My lord, the allegations mentioned in paragraph 28 of the moot problem, right to clean water, right to treatment, are baseless as they fall under fundamental principles of state policy which are not judicially enforceable according to Article 8 Clause 2 of the Constitution. My Lord, according to Article 102 Clause 1, the High Court Division on the application of any aggrieved person may issue or give such directions to the concerned authority for the enforcement of the fundamental rights. My Lord, which means for the enforcement of the fundamental rights which is enshrined in Part 3, parties can move to the court. My Lord, the rights claimed by LMC are not included in Part 3 and they have no judicial enforcement. My Lord, if the state is no judicial enforceable, LMC has no right to file the writ petition regarding this matter, my Lord. If my Lord has no queries, may I proceed with the second issue? Much obliged, my Lord. My Lord, I shall make two submissions in establishing that the denial of treatment by public hospital actually did not constitute a violation of fundamental rights. First of all, my Lord, the term medical care is explicitly mentioned in Article 15 Clause A of the Constitution. My Lord, this particular article is stipulated in Part 2 of the Constitution, which is the provision of fundamental principles of state policy, but fundamental rights are entering in Part 3 and nowhere in Part 3 right to medical care is regarded as a fundamental right. My Lord, in 𝒂𝒕𝒊𝒂𝒕𝒊𝒐𝒏 versus Bangladesh 44 DLR, in its judgment, para number 5, it is stated that these principles are not laws but are simply guidelines for the state, and that even if any law is inconsistent with the fundamental principles, that cannot be challenged in the court. My Lord, these principles are not also judicially enforceable pursuant to Article 8 Clause 2 of the Constitution. Rather, they act as a guide to interpretation of the Constitution and other laws of Bangladesh. So, the denial of treatment did not constitute violation of fundamental rights, my Lord. My Lord, here the denial of admission was due to lack of vacant beds, which falls. My Lord, may I have some minutes to conclude my argument?
1 minute.
Much obliged, my Lord. My Lord, here the denial of admission was due to lack of vacant beds, which falls under the category of availability of resources and therefore did not constitute any violation of fundamental rights. My Lord, if we go through the para number 24 of the moot problem, it is stated that Bangladesh is already grappling with under-resourced public health infrastructure. This means, my Lord, they are actually in lack of resources. So that's why, my Lord, when they're in lackings of their resources, not providing treatment is not actually constituted constituted violation of fundamental rights, my Lord. My Lord, if my Lord have no further queries, may I conclude my argument? Much obliged, my Lord. My Lord, after stating the fact before this honorable court on this issue, I respectfully submit that the petitioner actually has no locus standi to stand before this court, and the denial of treatment by public hospitals is not violation of fundamental rights, my Lord.
May it please your motions. I'm 𝒊𝒂𝒕𝒊𝒐𝒏 Islam, advocate for the respondent, appearing on behalf of the State of Union of Bangladesh. My Lord, my submission addresses issue 3 and 4, namely whether the failure of the state to give access to Article 2 of the Constitution and whether the state's failure to conduct an environmental impact assessment, monitor water quality, and prevent industrial waste discharge in the Nati River amounts to a breach of statutory and constitutional obligations. If you have no preliminary queries, I'd like to begin my submission on issue 3. Much obliged, Your Lordship. My Lord, I my lord, the state of Bangladesh humbly states that the failure to provide potable drinking water is not a violation of Article 32. My lord, Article 32 of the Constitution guarantees that no person shall be deprived of life or personal liberty save in accordance with law. My lord, this court has consistently held in Dr. Mohiuddin Farooq versus the government of Bangladesh, the scope of Article 32 extends to protection of life and environment. My lord, in another case of Dr. Mohiuddin Farooq versus the government of Bangladesh, his lordship held that the government's action should be evaluated considering its financial and administrative capacities, my lord. My lord, it has also declared a precedent in Abdul Latif Mirza versus the government of Bangladesh case that evaluating the reasonableness of government's action, implying that such action should align with legal standards and justifiable within government's capacity. My lord, in broader jurisprudence, all these statements together establish that the government is bound to provide and ensure protection of life and environment, but under its economic and other capacities. Meaning that if the government denies providing under its capacity, it will be an arbitrary and unlawful deprivation. In the present case, the government of Bangladesh has not acted arbitrarily, but rather within its bounds of law and with its capacity. My lord, I would like to draw your kind attention to Article 15, Clause A of the Constitution, which says that the state's duty is to ensure that every citizen has access to food, clothing, shelter, potable shelter, education, and medical care. My lord, the word food here includes potable water, stretching the government's duty to make potable water available for the people. But my lord, this should be highlighted that Article 15 ensures socio-economic rights, not fundamental rights, making it not judicially enforceable. In Qudrate-e-Ilahi Ponir versus Bangladesh, the appellate division held that fundamental principles of state policy are not judicially enforceable, meaning that the government is not fully bound to provide all socio-economic rights, but shall act on its economic and administrative capacities to fulfill the needs. The government of Bangladesh, in order to fulfill its duty of acting within its capacity, has taken reasonable measures. As a developing country facing resources constraints, the state has taken reasonable steps to ensure access to safe and pure drinking water. My lord, I would like to draw your kind attention to Para 26 of the Moot proposition that the government has marked the arsenic contaminated tube wells with red signs and also distributed clean water to the people living beside the Natai River. My lord, the government did not only stop here, the government aware.
Lord Council, it is also stated at paragraph 26 that the initiatives are slow, inadequate, and fail to meet the increased demand.
Much obliged, Your Lordship. Your Lordship, in this regard, I would like to assist you in paragraph 5, line 11, that says, these combined pressures have turned water access into a critical public health and environmental and governmental issue, my lord. And my lord, it has also stated in para 1 that after 21st century, the government of environment has, I beg your pardon, my lord. The government of Bangladesh has faced many kind of problems, like ensuring access to clean and safe water remains a serious challenge, my lord. Meaning that all the problems was not only happening beside the Natai River, but also all over the nation, making the government much more liable to provide all these rights to the people. That's why, my lord, I would like to say that the government had not only prioritized the Natai River, the government has a binding force on it to prioritize the whole issue in a sense to ensure potable drinking water for the whole nation. And that's why, my lord, the government can not only prioritize the people living beside the Natai River. Much obliged, Your Lordship. Your Lordship, with that, Your Lordship, the Bangladesh has also taken some steps to ensure the potable drinking water and clean water beside the Natai River by implementing the Aqua Sentinel, my lord. It has also stated in para 15 that Aqua Sentinel, in para 11, that Aqua Sentinel ensures potable water for over 20 million residents and 4 million hectares of agricultural land. My Lord, this was the biggest initiative taken by the government of Bangladesh to ensure potable and clean water. With that, my Lord, I'd like to move to my issue 4.
Lord Counsel, your friends earlier submitted almost denied, especially on the ground of locus standi. And you are not denying the locus standi, as well as you are supporting, you are trying to, you are ensuring that the concern of the petitioners will be addressed. You are taking the steps, is it?
No, my Lord, I do deny that the LMC does not have locus standi, because every person should be aware of its legal rights and duties. As the people living beside the Natai River never ever approached anyone legally because of the violation of their rights, LMC itself cannot stand in this court in representing them. Much obliged, your Lordship. Your Lordship, I shall make 3 submissions on establishing that no statutory and constitutional violation was held. First, compliance with statutory obligation. Second, the environmental impact assessment obligation. Third, the administrative inefficiencies. My Lord, the Water Act 2013, Section 3 recognizes access to potable water a highest priority right. To fulfill the obligation, the state invested in Aqua Sentinel AI, a sophisticated system for purification and monitor the water of Natai River. However, records shows that the Aqua Sentinel malfunctioned intermittently over the last 2 years, releasing excessive chemicals disturbing the Natai River's pH level. Hence, even though, my Lord, the Aqua Sentinel did malfunction, but in para 14, it has been clearly stated that the Natai River project Aqua Sentinel has 0% human error and no intervention from the human, my Lord. It is stated in line 9 and 10, my Lord. And also, my Lord, it has also stated there that the Niadilo achieved a 95% reduction on their own local rivers, applying the same technology, becoming a global recognized country in AI-driven environmental sustainability, my Lord. My Lord, after all these facts, these malfunction of the AI, of the Aqua Sentinel AI, was not due to negligence of the government of Bangladesh, but it was a supervening technological impossibility, my Lord. My Lord, with that, I humbly move to my second submission. I would like to begin my second submission on EIA obligations. The Environmental Conservation Rule 2023 categorizes industries into 4 classes under Section 5, green, yellow, orange, and red, my Lord. My Lord, the requirement on EIA applies only for the industries under red category under Section 15(1), my Lord. I have attached it in my annexure, page 31. My Lord, all the industries mentioned in this compromise does not belong to red category, my Lord. Does not belong to red category. All these industries, Natai River falls within green, yellow, and orange, making none of the industries 100% bound to go through EIA, my Lord. My Lord, the only red category industry mentioned in this compromise is Aqua Sentinel. And Aqua Sentinel, about the Aqua Sentinel's EIA assessment, the fact is totally silent about it. But the fact did hence us I beg just 10 seconds for that one. My Lord, the Aqua Sentinel, it has been clearly stated in para 10, line 4 to 6, that when deploying the Aqua Sentinel, the government negotiated or initiated talk to the local governments, and local government is an active member of Executive Committee of National Water Resources Council, my Lord. And this has been said in Section 9 of the Water Act 2013, and I have also attached it to my annexure, page 45 and 46, my lord. This means that, and also, my lord, the Executive Committee of the National Water Resources Council is the principal water regulator council, my lord. That means negotiating with this council makes an equal value of EIA to deploy the 𝒂𝒂𝒕𝒊𝒐𝒏, my lord. With that, my lord, I humbly move to my final submission that the petitioner's allegation highlighted coordination gaps between the Ministry of Industry and the Department of Environment, such as uncoordinated permit issuance and lack of enforcement. My lord, we do not deny these inefficiencies. However, my lord, in para 5 indicates governance dysfunction in the last line in Bangladesh become visible entranced after 21st century. And in para 4 further records that the state faced a severe economical downfall before 2024, all of which happened under the then government. My lord, these facts demonstrate that the existing coordination gaps are not product of the present regime's neglect, but rather the legacy of pre-governmental conflict. In order to solve these issues, the interim government has considered undertaking the implementation of the administrative reforms as outlined in para 4, my lord. With that, my lord, I would like to conclude my submission if you have no further queries. Much obliged, my lord. In light of these facts and legal principles, the state is acting in good faith and within its capacity. The malfunction of 𝒂𝒂𝒕𝒊𝒐𝒏 was unforeseeable, the EIA requirement did not legally apply, and reasonable actions were taken to protect water quality and public health. Accordingly, it is humbly submitted that the rule nisi be discharged. The council rests here.
Thank you.
Learned advocate for the petitioner are requested to make their rebuttal before the Honourable Court.
Your Lordship, may it please the Honourable Court? Much obliged. I will reserve 5 minutes for giving the rebuttal on behalf of the petitioner. And firstly, I will talking about the respondent's assertion about the petitioner's LMC has no locus standi, they argued, but it's a regressive interpretation that ignores the established principle of public interest litigation. And the Bangladesh, the respondent incorrectly characterized the LMC as a mere advocacy body, but they have no nexus with the people. But if we think that the people who are affected in the Natai River bank, they are incapable and they are also suffering for 2 years, which is mentioned in the paragraph number 23 of the Moot Fact. There was a report from the landmark national organizations. They showed that the 𝒂𝒂𝒕𝒊𝒐𝒏 AI has released 10 times more chemical in the previous 2 years. So why, how the people will address the court or go to the court if they are incapable to go to the court? We need to liberalize the definition of the aggrieved party as well. And regarding the previous expertise or connection with the environmental work, there was the other case references in Mohiuddin Farooq versus Bangladesh and also Bela versus Bangladesh and human rights, the 𝒆𝒅𝒊𝒂𝒕𝒊𝒐𝒏 versus Bangladesh. There it is showed that there need not to have previous expertise or legalized to stand before the court with to protecting the right of the people who are suffering. So it's obvious that the LMC has a locus standi in this regard. Your Lordship, they are also arguing that according to the 𝒂𝒕🔂 𝑫𝒆𝒏𝒕𝒊𝒐𝒏 versus Bangladesh case, that fundamental rights and also right to water, and the many other rights are also part of the part 3 of the Constitution, which are not judicially enforceable. But however, your court, according to the paragraph number 6 of the moot fact, which was agreed fact, both of the parties are agreed that the Article 32 and 32 is the right to water is interpreted along with the Article 32, which is right to life. So where there is a right to life is violating, there can be anyone who stand on behalf of them, and also it is enforceable under our Constitution. And thirdly, they are also denying the medical treatment to the affected people. According to the paragraph number 26 and 27 of the moot fact, the public hospitals are denying the admission of the people who are suffering. They could ensure a minimal primary or necessary or a first-aid medical treatment for them. It's totally irrelevant and also illegal that they are continuously refusing their admission on those hospitals. It's completely violating their Article 32 of Constitution and also violating of their right to life. And on the breach of constitutional and statutory duties, the respondents claim that extensive remedial measures were taken after the disaster, but not absolve them of the primary. And if we show that, according to the Section 3 of the Water Act 2013, the government says that the right to water is a fundamental priority and utmost right which they will ensure. And when they are not ensuring the right and they are not capable of giving, they should be liable on this regard, Your Lordship. Your Lordship, according to the they are also arguing that they have not exhausted all the preliminary or efficacious remedies. Your Lordship, according to the paragraph number 21 of the moot fact, it stated that their concerns are totally ignored, and the state are also failed to revise to take the initiatives, and also they are suffering almost for 2 years. So where there is the government itself violating their rights, where would they go? And also according to the Section 44 of the Environmental Conservation Act 1995, it states that the Department of Environment should ensure their powers and duty to conduct any further establishment or giving permission according to regarding the factories. So may I take 30 seconds to sum up my submission? Much obliged. According to paragraph number 20 of the moot fact, it is showed that the Ministry of Government and Forest initiated a cleanup project, and the Ministry of Industries continued issuing permission nearly factories without consulting the environmental regulation. It means they are itself violating their regulations, and they are also not complying with the law. So there is no remedy, Your Lordship, and there is no time to exhaust the efficacious remedies, as there is no efficacious remedies, and the violation is coming on behalf of the government. So this is our submission, Your Lordship. May the Council raise.
Learned advocate for the respondent are requested to make their rebuttal before the Honourable Court.
My Lord, may I proceed with my rebuttal? Much obliged, Your Lordship. My Lord, I shall refute the rebuttal of learned advocate of the petitioner's side in many points. I'll call it 7 points, my Lord. My first point is that learned advocate argued LMC is an aggrieved person, but here LMC is not an aggrieved person, as any of their rights are not violated. They're not affected directly, and their lack of sufficient interest in the subject matter of the dispute, as well as the rural people never sought justice, as every person should be aware of their rights and duties. Therefore, we urge that the petitioner has no locus standi. My second point is that the learned advocate argued that the government ignores fundamental rights by not admitting the sick people in the public hospital. I shall refute this statement, my lord, because Bangladesh is a country already grappling with an under-resourced public health infrastructure from the beginning of the 21st century. My lord, I should interpret the resourced word. It means not only essentials but also doctors and nurses, my lord. It's hard for the state to provide proper treatment to the people under life threat, let alone people suffering from arsenic water diseases. As the government cannot provide proper medical care to them, government has tried to prevent this situation by taking enough measures to provide potable water to the rural people. But as medical care nor potable water is a fundamental right but socio-economic right, the government's action taken under this capacity is a valid legal work, my lord. My lord, the third point is that the councils also argued that the Ministry of Industries continued to issue permits to factories without prior EIA. My lord, I shall make it clear that all industries mentioned in the moot proposition belong to green, yellow, and orange categories, while the EIA only requires for the red category projects as per section 15, subsection 1 of the ECR 2023. It is given in our annexure, page 31. My lord, my third and most important point is that, my lord, the learned advocates also argued that the Bangladesh in their written submission that the Bangladesh is a signatory party of ICCPR, and in their written submission, para 23 and 24, they used ICESCR to enforce the government. But my lord, I should clearly clarify it that in the clarification it has been clearly said that the Union of Bangladesh has not been a signatory to any relevant bilateral or multilateral treaties, convention or accords except as indicated in the facts. It is also attached. I beg your pardon, my lord. It is also attached in our annexure, page 43, my lord. My lord, my next point is that the petitioner also argued that the Aqua Sentinel AI project's malfunction was ignored, and it was because of the government's irresponsibility, my lord. I shall make it clear that in para 10, line 4 to 6, where it has been clearly stated that the government has implemented the Aqua Sentinel, I beg your pardon, my lord. In para 26, it has been clearly stated that the Aqua Sentinel has zero human error and no intervention from the human, my lord. And also, the NIADILO has successfully reduced 95% of the water pollution in its own country by applying the same technology. I humbly ask for 30 seconds, my lord. Much obliged, my lord. My lord, also the learned advocates said that the Marine and Ocean Justice is a landmark researcher, but my lord, it has nowhere to be found in the fact. With that, my lord, I humbly complete my submission here. The council rests.